Good morning, everyone. Had I had more imagination in making up a title for my presentation, this would have been CILC, CIL, but that's already did that for you. So that's the gist of my argument. Thank you, Mike. Okay. So the ILC, the International Commission, is, I think, to most of us, the elephant in the room in custom creation, assertion, identification in international law today. Why am I saying that? Because the end products of the International Law Commission, no matter how they are called, how they're named, they are perceived by international lawyers / courts, as Vladislav has pointed out, to be an accurate reflection of lex lata or lex ferenda. So this is in itself, let's say, not problematic, but it becomes problematic if we look into the process through which the ILC arrives at this outcome. So what is the function of the ILC, to state it from the outset? It has a double mandate. First of all, to record the progressive development of the law, and the second function is to codify existing law, customary international law. So what I will argue for today is that there is a need to for a methodological rigor, not only in the way the ILC is codifying custom, okay, that everybody is saying, okay, we need a methodological rigor for custom, but also the ILC needs a coherent methodology and a strong methodology in the way it's asserting, elaborating, you pick it after. I explain what it is, the progressive development of the law. Okay. And this is even more, this need is even more pressing today because the ILC, the project it undertakes, the more recent ones, shift, I would like to think, towards the progressive development of the law rather than customary international law. Okay. At the beginning, it used to be more custom, and now towards progressive development. At the beginning, it's normal that we start with the rules we think are harder and easier to infer, and then we go on to addressing more, I don't know, prospective issues or whatever. So don't be intimidated by this. This is, I will go through it, hopefully telegraphically. You cannot even see it, right? So at the beginning, I will talk about the nature of what is progressive development of the law, okay? How we distinguish it with codification, how we distinguish it with lex ferenda, even if that could be a very bold statement to make, and what is its function. The second part of my argument will be how is this progressive development of the law elaborated or asserted by the International Commission, and then finally, after arguing that the ILC has no methodology in how it elaborates or asserts the progressive development of the law, I will try to construct such a methodology. All right? Okay, I hope this is clear. Now, first of all, the distinction between codification and progressive development in the ILC. So in theory, there is Article 15 of the ILC Statute, which you probably cannot read. So what I said before, codification is about formulation and systematization of rules of international law in fields where there already has been extensive state practice, precedent and doctrine. On the other hand, progressive development is the preparation of draft conventions on subjects which have not yet been regulated in international law or in regards to which the law has not yet been sufficiently developed in the practice of states. And I have italicized states because this document reflects a very state-centric idea or of how customary law is formed. So, but in practice, this distinction never made sense. And what the ILC does is, as Crawford has described it, is a functional hybrid between these two exercises. And the ILC in its yearbook has said, and I quote, "A single consolidated procedure based on its statute has been evolved by the Commission out of the need to incorporate elements of both lex lata and lex ferenda in the rules to be formulated. Okay, so it's a mesh of everything. Okay, and the worst part is the ILC very seldom says what is lex lata and what is lex ferenda in the context of the same project. Okay, so it's on the eye of the beholder or of the interpreter or the applier to find out the status, the normative status of the rule they are potentially applying or interpreting or whatever. You understand the problematic about it. So, what is the progressive development of the law? The ILC, in its statute, in this yearbook that I read before the quote, sort of makes a tautology between lex ferenda and progressive development of the law. Lex ferenda is the law as it ought to be, something that is desirable as law. Okay, and I have an example from the recent identification of customary law project, where Sir Michael Wood mentioned in the context of commenting in Article 14 that the opinions of writers sometimes seek not merely to record the state of the law as it is, lex lata, but to advocate its development, lex ferenda. So again, we see, this is my colleague probably, yeah, okay. So we see again a tautology between the two, okay? However, I believe that the progressive development of the law is the content that we need to establish in order to result in a lex ferenda rule. So lex ferenda is an assertion about the normative status of a rule. Okay, so what's the status? The status is something that ought to be law. On the other hand, the progressive development of the law is an assertion about the substance of the rule itself. Okay, what does it depict? Okay, it depicts how the law goes, how the law progresses. Okay, and this ends up in a rule that has this normative status. So to the extent that lex ferenda, so a rule with an ambiguous legal status, okay, or an unclear legal status, okay, normative status, I mean, leads and it's been acted upon, okay, and leads to lex lata, then in that sense, someone can argue that the progressive development of the law eventually forms part of the formative process of customary international law. So it's at the beginning of the whole process. And I'm not sure that you are familiar with that face. This is Erwin Schrödinger. He has been one of the most famous physicists of the 20th century. He has talked about the theory of quantum superposition. Quanta are these subatomic particles that we even today do not know how they behave, what are their qualities. So because in a state where we don't observe quanta, okay, physicists have said that they can have a double state, one state superposed on the other, okay? So they can both be white and black, to put it in vulgar terms. So in order to explain this, he created he put it forward in the idea of a dead or alive cat experiment. So he said, imagine a cat in a sealed box that you cannot see, but inside the box there is a vial of poison, and there is a hammer hanging on top of it, and there's a 50% chance that the hammer will break the glass and the poison will spread and the cat's going to be dead. But unless you look inside, you cannot know whether the cat is alive or dead. So I'm using this as an analogy to how lex ferenda works. So unless this lex ferenda rule has been acted upon, okay, by those actors that create customary law, the lex ferenda rules exist in a state of quantum superposition, let's say. Okay, so there are two categories of cases that the ILC has said lex ferenda is the elaboration of progressive development of the law is possible, and hence lex ferenda. So this categories is when you have no, it's a completely new field, you start from blank sheet, ex nihilo, okay? So you cannot induce anything, you can only deduce something. And the second category is where the law has not yet been sufficiently developed in the practice of states says ILC Article 15, but today we can question this state-centric view. Thank you. So you have an impossible outcome, basically. So you have two different, or 3 or 4 different proposals, and you don't know where you come up with, what you can come up with. A point of caution here, progressive development of the law does not mean law reform. It doesn't mean we want to change something. Okay? It means we want to know where the law is going at. All right. And since Lex Lata, so i.e. customary law, we have a methodology, let's say, or at least some law or some guiding principle as to how to elaborate it, at least we think we do. So it's a matter of supposedly objective determination. Lex ferenda is a completely subjective statement. So the question is, since this is a subjective statement, so somebody thinks that something should become the law, okay? Do we have a methodology for that? 2 ideas. So first of all, I have to tell you that in theory, I've tried to do a good research on what has been written on that, very few things, if not anything. So first of all, most commentators think that the ILC is completely unrestricted when dealing with this issue. It can say whatever it likes. If the ILC that something is lex ferenda, then this is automatically lex ferenda. Alain Pellet has said something which I find very instructive. He said, the Commission's duty is to try to understand the logic of existing rules and to develop them in the framework of this logic, not to change the underlying logic. So there is some kind of qualification as to what can be the progressive development of the law, says Alain Pellet. So what is this qualification, if there is one? So, and the example I'll try to talk about is something I dealt with in the context of my PhD. So it comes from the ILC project on the responsibility of international organizations. So as you know, in order for international responsibility to occur, you need 2 things: attribution and breach, Article 4. Okay, this is, almost a general principle of law. All right. So in the context of the Articles on Responsibility of International Organizations, this, everybody agrees, is Lex Lata, is customary law. Okay. However, when it came to drafting Article 15, the article on direction and control exercised over the Commission of an International Lawful Act, the ILC has, in the commentaries to this article, has said that this is the progressive development of the law, and I can tell you that in these cases, the entity, be it a state or an international organization, that directs and controls the international lawful act of another entity or of another state or international organization incurs international responsibility, even though this act is not attributable to that directing and controlling entity. So the ILC says this: the progressive development of the law, okay, can be something that runs counter to Lex Lata. Okay, now this may seem okay because it's the ILC, can say whatever you like, but can it really? I believe that if we think about international law as a system of rules, okay, that builds systemic relationships between the rules, as the International Commission itself has said in the fragmentation report, Customary. So therefore, existing legal rules, okay, should pose some limitations as to what the progressive development of the law should be. The law cannot contravene itself, okay, in the process of such a formation. If we had a legal indication as to where the law is going, so if we had some practice, okay, or opinio juris, or something that tells us that Article 15, for example, okay, should be drafted in this way, okay, then we could argue for a lex ferenda exception to the Lex Lata of Article 4, which says that for international responsibility, I need breach and attribution. But if you have no legal indication, I need to insist on that, okay? You cannot on the top of your head, okay, say that I think that the law is going towards the opposite direction than existing law. So again, these are some tentative thoughts, and I would really like to hear your thoughts on that, because again, I'm saying there are very few things that have been written on this. And The second scenario is what I would like to call the impossible choice scenario, again in the context of the, and I finish with that, Chair, in the identification of customary law project, and this has to do with conclusion for paragraph 2. We had a panel on this related to this topic yesterday, so whether international organizations can contribute to the formation of custom. Here, Sir Michael Wood had two, I'm finishing with this, thank you, had two basically choices. They do or they do not contribute. There was not a third option. But states and in their comments and also commentators were split. Okay, so he had to make a choice. So he said it was, Sir Michael Wood believed that present draft conclusion was reasonably balanced in the draft conclusion, were reasonably balanced in their approach to the role of organizations and that they reflected reality. Okay, so policy consideration. He did not think that draft conclusion 4.2, which was cautionally drafted, could reasonably be described as lex ferenda, so not even lex ferenda, okay, when you have an impossible choice, as it had been by one colleague of his. Anyway, what I'm heading at is that, final statement, there is no methodology on how we elaborate lex ferenda, and maybe it's high time we have one because of the repercussions for international court tribunals on the ILC's projects. Thank you very much for that.